Hello, everyone. Good afternoon to everyone from Eastern Canada and good morning on the West Coast. Thank you for joining us today for this special webinar, What You Need to Know About Wills, in 40 minutes. My name is Michelle Capobianco, and I'm the CEO of Pancreatic Cancer Canada. I know many of you are familiar with us. You're part of our extended family. But for those of you who are new and wanting to know a wee bit about our organization, we are battling to increase the incredibly low survival rate of pancreatic cancer patients, which currently sits at 8%. We do that by funding some groundbreaking research right across the country and into the US as well. So while research is our highest priority, we also support families, caregivers, as well as patients. Those are my dogs, and I apologize, I can't control them. So I'm going to introduce you now to Wally Weiner. Wally spent many years as a practicing lawyer, during which time he assisted in the preparation of well over 1,000 wills and powers of attorney. He has also acted as an executor for former clients. So in addition to his professional experience, he has a deep personal understanding of the complexities and obligations that come with taking on that responsibility. Upon retiring, and Wally was very specific, he asked me to emphasize it was a voluntary retirement. He wanted to continue to contribute to the field and he has become so passionate about. To enhance his practical and legal background, Wally became certified through the Canadian Institute of Executor Advisors. This allowed him to keep up to date with legislation and has continued access to a host of resources to benefit his clients. I am pleased to introduce you to Wally Weiner.
Good afternoon, and thank you, Michelle. Yes, you should have a will. Yes, your spouse should have a will. Yes, there's more to estate planning. You should also have power of attorneys and possibly health directives. Yes, you should review your will every 3 to 5 years. Today's webinar will be similar to an iceberg. You only get to see the tip of the iceberg. There is so much more below the surface. A few preliminary notes. I do not prepare wills. That is the job of your lawyer. I do not want to be your executor. I do offer advice, options, alternatives for your consideration, which should make your appointment with a lawyer more effective, more efficient, more productive. The Law Society of Ontario has said that I cannot talk about a law or legal matters. And recently, Ontario has made significant changes in the area of estate law and the administration of estates that may well impact your current wills. So please review your existing wills in the near future. As a lawyer, I would often get that Monday morning phone call. Hi, Wally. I know you have been badgering us for years to come and see you, especially after the twins were born. Can you believe that they will soon be 4 years old? Anyhow, Sally and I are leaving for holidays on Friday. Can we get in tomorrow? Our best time is 10 o'clock. All we need is a simple will. In my consultations, I started off with a checklist of some 18 areas of concern. It gets enlarged during our conversation, of course, as we dig deeper and deeper into the topics. Some of these topics are not conducive or necessary to discuss because they may not be applicable. The conclusion is that there is no such thing as a simple one-size-fits-all will. As I look at you, the registrants, I welcome you to the 50-50 Club. This is not working. One moment, please. Yes, 50% of you will have a will, and 50% of you do not have a will. And we will come back to that statistic a little later. Of you that do have a will, unfortunately, 15% are outdated or invalid, leaving only 34% of you having a valid will. A will becomes outdated or invalid due to the death of a beneficiary or an executor, improper execution or witnessing of the will, the finding of a lack of capacity or duress made when you made the will, changes in available assets, or changes in provincial or federal legislation. I believe there are two main reasons that Canadians put off making a will. First, they feel the world is upside down. They just want it to stop spinning. Or their own lives, their own families are in a chaotic mess. Marriage, common law, same-sex, children, stepchildren, grandchildren, separation, divorce, job loss, new business, being a caregiver, and any combination of the above. Believe me, there is no perfect time. It is never too early to make a will, but it may become too late to make a will or change due to incapacity, illness, or premature death. For today's webinar, we've selected 6 topics that are the most troublesome in many of my consultations. So let's begin. But one of the first questions your lawyer will ask, who will be your executor? For the record, most provinces use the word executor. Quebec uses the word liquidator. A few years ago, Ontario moved to the word estate trustee. In all cases, the role of that person is the same. Now, research shows that 99% of will makers, who are also called testators, will appoint a family member. With that percentage, many of you at some stage could well be an executor. So perhaps bear that in mind as we go through the following comments. So to begin with, if married, you name your spouse as executor. Just remember, your spouse is aging with you and perhaps going through his or her own health issues. It is also extremely important that you also name an alternate or second executor in the event that the spouse becomes unable, unwilling, or predeceases you. If you have adult children, your question always is, do I name the eldest or all 3 or 4 of them? Your lawyer should dig into that question with you. Where do your prospective executors reside? Are they all within Ontario, within Canada? Are they world travelers? Have your children even spoken to one another in the last 3 or 15 years? Do they have the time? Many wills take anywhere from 18 months to 4 years. Are they trustworthy and reliable? Perhaps your son at the age of 40 who just moved into the basement apartment at your home has been unemployed for the past 3 years, is behind in his filings of his own income tax returns. Yes, he would certainly have the time, but is he the best choice? If you name one child or even one non-family member, again, name an alternate executor. If you have 2 executors, the law imposes a mutually acceptable decision, in other words, consensus, So consider some mechanism for breaking that deadlock. And if you name 3, is the decision of 2 binding on all? And does Mary, her decision, does it have to be always with the majority because she's the smartest? If you recognize that your named executor does not share your passion or interest in your stamp or coin collection, but they may not be aware that a Wayne Gretzky rookie card could fetch $465,000, or a Kobe Bryant card lying in the top sock drawer of yours could be worth twice that amount, or know anything about your business. You certainly do not want your executor to say, hey, we have to clean out the attic, the garage, or in fact, any room, and just call 1-800-GOT-JUNK. You may recall recently that a Value Village in British Columbia, the employees opened some shopping bags and to their shock, found $85,000 in cash. While that was not the result of an executor, it was a lack of due diligence, perhaps on someone acting under a power of attorney and helping the senior move into a residence. A couple of quick notes on children and grandchildren. If in your will you refer to the beneficiary as being your child or children, that means your child or children by blood. So stepchildren that you love and have cared for over 20 years are not included unless you name that child in the will or the child was adopted. If a child is receiving a government pension, be careful that any bequest does not put that pension in jeopardy. In Ontario, we consider the use of a Henson Trust. Parents often wish to divide their estate equally, as they believe that this will remove jealousy and friction. Firstly, there is nothing you can do to preclude friction that has been boiling under the surface for 30 years. It can now surface because you are no longer around. Secondly, equal is not necessarily fair in the eyes of your children. One child might have been a caregiver for some 7 years, while the other made the monthly telephone check-in phone call. One child may have worked at the restaurant or business with you side by side for 20 years at minimum wage, while the others have traveled the world to find themselves. If you want to see your lawyer roll his or her eyes, all you have to say is, my children will never fight. As a testator or will maker, be aware that asking anyone to be an executor may be, in your opinion, an honor. To the executor, it may be a burden and stressful. In a survey a few years ago, the numbers of executors who experienced legal issues, 26%, emotional issues, 31%, and administrative issues, 47%. All you have to do is check with the Ontario Premier Doug Ford, the executor of his brother Rob's will, where his sister-in-law Renata is suing him for $16 million. Or you may want to check with past President Donald Trump, who will soon face his niece Mary with a significant lawsuit. In Ontario, there are also legislative requirements which can attract fines and even jail time for your executor. And it is not always millions of dollars that causes an executor to be sued. You can be sued due to poor judgment, negligence, failure to protect some asset, doing or not doing something that an aggrieved beneficiary feels that you should be liable for. The good news is that the job of an executor can be made easier with communication. Your estate should not be a scavenger hunt for the executor. Possibly, you can advise them where your assets are. You can advise them the location of those assets. You can indicate to them who the preferred advisors are and give him or her some direction while you're alive. On the plus side, executors may obtain liability insurance. There are websites, estate advisors, and many professionals that can assist you if you seek advice. Executors may also apply to the courts for directions as to what the will means. I was recently informed of a new website that should be up and running within the month that will provide guidance to those in a fiduciary relationship, like executors, power attorneys, and financial planners. pfsi.com should get you on the right track. Excuse me while I take a drink. Another area of concern is a cottage, especially in both the Toronto area and on the West Coast. Cottages have increased about 30% in the last 2 years. If that cottage has been in the family for years, that could impose a large financial drain on your estate, often giving the executor what is called a liquidity problem, meaning not enough cash. Perhaps it's called liquidity because it's going to drive your executor to drink. I will avoid and evade the tax issue, such as spousal transfers and deemed dispositions. You have wonderful memories of your 3 children growing up at the cottage, and now they are married, and there's 7 children, and you want all 13 to enjoy the cottage and have their own blissful memories. There just might be some issues to deal with. How do they determine usage and for how long during our short summers? One lives within a 3-hour drive, one lives in the Maritimes, and a third in Europe. Or worse still, they all live within 3 hours drive of the cottage. How do they contribute to annual taxes, insurance, maintenance, the new roof, and the septic tank? And how is the accounting maintained? And what about if 1 or 2 of the children fail to make annual payments? How do they deal with that yellow shag rug that one child just detests? How about the child that would really rather have a 1/3 cash interest paid out and forget the cottage? Is the cottage being transferred with or without the $300,000 mortgage? Are the sailboats, motorboats, skidoos, trucks, tractors included in the transfer and are meant to be used by all? Can grandchildren have the cottage for their prom events or classmates' reunions? These questions could be resolved while you're alive, but usually they are not even raised, as no one likes to talk about death. Perhaps the cottage should be sold by the estate, possibly with a first right of refusal to a family member. Or you set up a trust and fund maintenance for 5 to 10 years. Perhaps you utilize life insurance. All this can become complicated, and it does create many lawsuits between loving children and destroys families. Next consideration are pets. Another statistic for you is 60% of Canadian households include an animal. 89% of those owners consider their pet a member of the family. Yet only 7% set up a trust for their pet. And pets are not inexpensive, as many of you know. Average lifetime costs for a dog runs $30,000 to $42,000. For a cat, $22,000 to $31,000. Know that you cannot leave money directly to the pet. As in law, your pet is like a piece of furniture, not Chesterfield that you love to sit in. Consider naming an individual. Give them funds to cover their expenses and provide direction for money not spent on the animal. Two examples that I like to refer to is Leona Hemsley of New York. She left $12 million to her little dog, Trouble. A court reduced Trouble's support to $7 million and gave the family, who were neglected entirely in her will, $5 million. Recently, an 84-year-old man died in Nashville. He left Lulu, his border collie of 8 years, to be looked after by his neighbor. The dog has a life expectancy of 6 years. The dog has a trust of $5 million. By the way, the neighbor, who is 88 years old, has already exceeded her life expectancy. We're going to move on to passwords and digital assets. Sorry, I missed the pet one. All right, we're now on passwords and digital assets. I get carried away with my own presentation. Some 34 million Canadians use the internet. Yes, 96% of Canadians. By using our desktop, laptop, tablet, smartphone, for photographs, social media, emails, Instagram, Twitter, Facebook, PayPal, banking, and loyalty points, we are leaving a personal digital footprint. It follows you for life. As any want-to-be politician finding out that that great tweet from 15 years ago or that wonderful photograph is coming back to curtail their new vocation, or losing a job due to some tweet, or losing your lawsuit for serious injuries, but you posted yourself water skiing. Your footprint may be a potential privacy security risk for your family. Minor risk, you can ask Mrs. Cruz. Appreciate that many online service providers state that a deceased has no ownership over their online assets. Facebook, after a number of lawsuits, will allow references that you are deceased and permit messages to be posted. They will not allow for removal or change to any existing content, no matter how embarrassing that may be. Canadian law currently is very deficient in providing executors access to websites, but I would still ensure that digital assets fall within the executor's terms of reference in your will. As I mentioned, your footprint lives on and remains. While I never utilized social media when I was a practicing lawyer, I was encouraged that I needed to do so when I became a consultant. Last summer, I received a message on LinkedIn from an acquaintance in Montreal that I knew some 10 years ago, and he wanted to connect. Apparently, some algorithm matched us as having one friend in common. I declined as I saw no economic advantage, since the individual had died 2 years previously. Yes, it was creepy. And yes, technology keeps you alive for years and years. The average Canadian has 10 loyalty club memberships. You can do your own tally later. Again, your will could record or should record the card and its number in your will, the number of points in your will, and possibly gift the points to a spouse or child. Equally important, of course, is to ensure your executor has all passwords and logins. Not all loyalty points will allow for transfer. If they do, they will require proof of death, and some request the portion of the will making the gift. Many of the cards allow only 60 to 90 days to effect the transfer, or they are forfeited. A clear problem is for any executor who is not aware of your numerous memberships. More important is that the death often terminates the points. They will not allow a transfer. These include Delta, JetBlue, Shoppers, Loblaws, and Canadian Tire. Perhaps putting a second authorized name on your card may help. Better still, using your points while alive might be a good idea. Definitely do not put your password and logins in your will. The last topic is charities. In addition to my interest and passion in the field of estates, I have been involved with many fundraising activities over the years, from hospitals, the YMCA, community endeavors, hospices, and for many years, the Canadian Cancer Society. The Canadian Cancer Society is like the Walmart big box store. There you will find support from prevention to treatment. They provide a holistic approach to cancer research for more than 14 different cancers, including brain, breast, and pancreatic. Last year, Canadian Cancer Society contributed $42 million to all research. Only, and only is my word, only 1.8 million went to pancreatic research. Until 2 years ago, I had never heard of Pancreatic Cancer Canada, and as a result of becoming somewhat educated in this organization, I found out that pancreatic cancer affects both men and women almost equally. The pancreatic cancer is the third or fourth most deadly cancer, in that the 5-year survival rate for the pancreatic patient is less than 8%, with most dying within 2 years of diagnosis. Compared to lung cancer, which has a 5-year survival rate of 19%, or breast cancer, which has a 5-year survival rate of 88%, or prostate cancer, which has a survival rate of 93%. Pancreatic Cancer Canada, which was established in 2006, realized that a more focused approach to research was needed, and it has, as Michelle noted, aligned itself with the best research being conducted worldwide with the goal of moving the needle for survival from the less 8% to match that of other cancers. A needle that has not significantly moved in the last 40 years. And so today, I am pleased to have the opportunity to speak about charities in general, and hopefully many of you will consider Pancreatic Cancer Canada as a most worthy recipient of your donation in the near future. There are some 170,000 Canadian charities and not-for-profits. The federal government has some 20 incentives built into the Income Tax Act to help encourage Canadians to make a charitable contribution. Many argue that Canada has one of the most generous tax environments in the world. Why do people donate? The top 3 reasons are easily interchangeable. Someone you cared about, someone you respect asked you, or perhaps is affected or died from an illness. You trust the charity and you know that they do good work. You want to make a difference. You want to help the charity reach a milestone. You want that pride in giving. I would suggest that a charitable gift is often a more spontaneous and modest gift. It's made at a funeral home. It's made at the front door. It's made at the grocery store checkout, or perhaps Canada Helps. A planned gift is a significant contribution to a charity or foundation that is arranged while you are alive and may be given while alive or upon death through your will. It is often called a legacy gift. It can come in various sizes. It can be in cash. I'm told. It can be in cash. It can be a piece of art. It can be a life insurance, or it can be stocks and bonds. While it was interesting that the obtaining of a tax receipt was not high on the list of why one gives, the gift and how you give it can have a great impact on your estate, a positive impact for your beneficiaries and a charity. Do yourself a favor, speak to a financial planner, to your accountant, talk to Michelle, talk to Jordana, and I'm sure that they would be happy to help you. There are always wrinkles in any example regarding tax benefits, and so please, no emails. You recall earlier I spoke of a parent who wants to treat their children equally. So mom has an estate with only 2 assets, her RIF and her home. Conveniently, they are both valued at $600,000. She designates Mary as beneficiary of the RIF, and she leaves Beverly the house. They have each been treated equally. What more do you want? Well, CRA knocks on Beverly's door and advises her that there is about $300,000 owing on the RIF. That is because the RIF is as if cash at mom's death, and it's called a deemed disposition. So Beverly can either sell the home or put a mortgage on it. So what was originally an equal gift is no longer equal to the beneficiaries, and the sisters no longer love one another. Yes, with advice, there could have been a better result and a more equitable one. That happens only with planning. How to get the best bang for your buck. Remember, our motivating, encouraging government allows you to do good deeds. And they do that by the tax deduction, which reduces taxable income before tax bill is calculated, or by tax credit, which reduces the amount of tax owing after the bill is calculated. The tax treatment of RIFs, bank accounts, shares are treated differently by CRA. So professionals can help you determine what may best be for your estate and for your desires. The question often arises, how much money should I leave my children? Or can I leave to a charity and not deprive my family? Firstly, I do suggest that if you can assist your children or grandchildren while alive, do so. Enjoy their appreciation and hopefully their success or achievements. Secondly, with direction and advice, you can often do both. Another example, and please don't send me emails telling me what was wrong with it. 50-year-old couple obtained a $50,000 life insurance. They pay $1,600 a year for 10 years, so it's paid up. They pay a total of $16,000. They make Pancreatic Cancer Canada the beneficiary. On the death of the last one, the insurance company pays Pancreatic Cancer Canada $50,000, and it allows the estate a $20,000 tax credit. The estate wins, the charity wins, and you've done a good deed. There is no mystery with the word planned giving. Perhaps it should be called intelligent giving. It could also be called last word giving, because it allows you to have a say on how your gift will be used by the charity, whether it's in operations, education, wellness, or research. Remember the reference to the 50-50 Club? That statistic was based on those 35 years of age and up. Apparently, we do get smarter as we get older. For as those over 75, 90% have made a will. Just don't wait that long. You may lose your capacity or have that untimely death. We had a poll, and many of you participated in, and I thank you. Of the group that I'm now talking to, more than 70% of you have wills. The sad part is that over 30% of those wills have not been looked at or reviewed in 10 years. Throughout this presentation, there was a thread that ran through all the topics, and that was the importance of communication. Talk to your executor, explain your desires, detail your assets. Talk to your children and discuss why you made a decision in your will as to what not being equal. Talk to them about the cottage and any other asset that you wish to give. Are they interested in that asset? Review your pet's future and talk to the professionals. Earlier, I said your will should be reviewed every 3 to 5 years, but also I noted that the Ontario government has come up with a number of important changes to the administration of the wills, and also as to changes in maybe marriage and common law relationships. So please, if there's a change in your marital status, see the lawyer. If there's a change in residency, if you move from one province to another, the states are under provincial jurisdiction and may not be the same in each jurisdiction. There could be a change in your net worth, up or down, that is important, and it may affect some gift that you did make that can no longer be made to whatever beneficiary it was to. If you have new acquisitions, if you have a condo now in Arizona, understand that their law may be completely different, and you might want a will, in fact, dealing with just that asset. And of course, death or incapacity of an executor, the beneficiary. If I take a moment, I want to go back to a change in net worth. And maybe those of you from the West Coast know the case that is now going on with Elena Murray. She was 99 when she died in 2017. Her will, made in 2003, left $440,000 to the family, and her residence, which she thought was equal value to the Humane Society. At the time, she felt she was dealing with them equally. However, when she died, her estate was worth over $2 million because, of course, her house in Vancouver increased in value. And the Humane Society is now looking for its 1.5 value of residue. To add to this complexity, she made a handwritten note when she was 99, in which she limited the Humane Society to $100,000, wanting to give the increased value to her family. Unfortunately, that was unsigned, undated, and there was, of course, a question of capacity. So there was a tug of war now between the family members and the Humane Society. Who you should consult with, there's a list of names here. You can go down them. It may be necessary for you to consult with 2 or 3 of these individuals in order to get the information you want. Many of them also have the Institute of Chartered Accountants degree or approval amongst these professionals. In closing, a couple of very brief stories. I spoke about the need to update your will. There are many examples. The one I find most difficult to understand is that of the late Robert Kennedy, who was running for president of the United States in 1968 and was unfortunately assassinated. In his will, he named his brother John as executor, who had been assassinated 5 years earlier. Robert was Attorney General of the United States. He had 1,500 lawyers under his jurisdiction. He had resources. It wasn't due to lack of money. Naturally, it was resolved with expensive court case with different parties saying they should be the administrator of the estate. Lately, we heard a lot about royalty, and so I have to bring that up right now. And we're going to talk about a king, Larry King, popular host of the Larry King Live Show. He has an estate of about $50 million, and he had a will made in 2015. In 2019, he left a handwritten note, leaving funds to his 5 children. He left out his wife and his earlier 7 wives. Unfortunately, in that little handwritten note, he did not revoke his previous will. He referred to funds. So what does that include? He did not name an executor. In his note, he did name 5 children, but shortly after making that, 2 of them died. He made no further changes. Was he competent when he made his note? Was he under duress or under medication? Those are questions that the courts will have to deal with in that jurisdiction. So I hope that somewhere during the past 30 or so minutes, 1 or 2 lights went off, and you will now undertake a will or review your will. Save your family stress and litigation. Leave a legacy of appreciation and love. I see Michelle has a message or a note for me, so I will now turn this over to Michelle.
Thank you so much, Wally. Now everyone listening knows why we love Wally so much at PCC, what a great friend he's been to our organization. And I really encourage all of you to reach out to him. Any questions you have. Wally, I had a question from the audience asking you to repeat a website address you gave. Could you do that again for us, maybe?
Yes, I will. I'll send it to you by an email. So you can also
Perfect.
circulated.
Perfect. I'll tell you what, we'll do it in the follow-up.
PFSI.com.
So
It's not up and running yet.
Peter Franks, samindigo.com.
Wow. Okay. You're a fast thinker.
I tell you how much of a fast thinker I am, Wally. When you started talking about those dogs, and I remembered that my dogs barked all through my intro of you, I immediately cut them out. So that 3 million that was going to the dogs, not happening anymore.
I hope you didn't just take a pen and scratch out. I hope you called your lawyer and said, I want to make a change to my will.
I will definitely be doing that. We have a few questions,
Yeah,
and
I
people
see
can
that,
also.
Mark has given us the official
Yeah.
PFSI.com.
Thank you, Mark. So I've got a couple of questions here, Wally, that have already come in. Someone has asked, I've already written my will, but now I want to add a bequest. Do I have to rewrite my will to do so?
No. You can contact your lawyer and do a codicil or an amendment. Can I get this and maybe share the screen? Do not scratch out, do not use whiteout to make whatever change you want to make or just insert it. See the lawyer because it also has to be witnessed properly. Also, if you're going to leave to a charity, make sure that you have the proper name of the charity.
Well, thank you. That actually perfectly segues into the second question, which is, do I need to tell a charity that I'm leaving a gift to them in my will?
You don't have to, and unfortunately, 80% of charities don't know that they are going to be receiving a gift through the will. I don't think that is smart. I think you want to have a discussion with the charity, make sure that it's going to some use that the charity wants to promote, and can use your money wisely. Also, I think it's important if you're going to give to a charity that you designate whether this is to the national organization, a provincial organization, or the local municipal chapter or unit. That sometimes runs into headaches with national boards who, of course, feel they're entitled to all the money once their charity is named.
Okay, we have a question from Ryan. If co-executors are named in a will, are all decisions made jointly between both executors at the same time, or can each executor make decisions individually on their own without the other co-executor present?
It depends. Well, you don't have to be present to have a unanimous decision. It could be made over the telephone or whatever, as long as there's no dispute about it. But there was another aspect. Do you want to repeat that quick?
Yeah, absolutely. Co-executors are named in a will. Are all decisions made jointly between both executors, or can each one make an individual decision?
Now, the will might say that there are two executors and they are named jointly and severally, which means that they have to make the decision together meaning the same decision. Or if it says severally, one executor can make a decision on a topic. That doesn't mean the other one will agree and won't say, hey, you can't do that, and they get into a tussle.
Excellent. Okay. No tussles wanted. What are Ontario's probate fees and how can I avoid them?
Well, you can avoid them by giving away all your money while you're alive. Or some people feel they don't have any assets, which is usually untrue. They usually do. There's no way to avoid them other than good planning. You can minimize the probate taxes. Probate seems to, people don't even know how much you're paying for probate fees, but it seems to be a major call in their heads. So for $100,000 estate, the probate fee is $750. For a $700,000 estate, the probate fee is $9,000. These are Ontario, by the way, $9,750. For a $2 million estate, it's just under $30,000. So it goes up, but it goes up with your estate. So I don't think at any stage is really that terrible. But again, getting advice, getting planned giving in your mind to see whether a credit or a deduction is preferable is a good way to minimize your costs. And not all assets carry with it a probate fee. And so that should be discussed with your lawyer, because I'm getting close to giving legal advice.
Excellent. Okay, we have a few minutes to take other questions, so I'll wait while people have the opportunity to populate the chat. If anyone's struggling to find out where they can submit their questions, at the bottom of your screen, there is an icon that looks like a bubble, someone speaking, and it says chat. If you click on that, you can write a chat to all panelists or to everyone listening. So I'll just say, for PCC, we have been fortunate to have been left in people's wills. It is true that we often aren't told till after the person has gone, and then it's usually a year to 2 years before the funds are dispersed. We have had some people, once a loved one has passed away from pancreatic cancer, the surviving spouse then decides to get a life insurance policy and redirect that to us, or I think it then becomes something much more open and personal to them. Pancreatic does. Kimberly would like to know, what age should children have wills?
I would think that children do not probably need wills until they're about 25. I will say that I think any child over 18 should have a power of attorney. I know this is not power of attorneys, but with children going out of province and out of country for their education, if they get sick, they are of age and parents have no jurisdiction and can't even interfere or get any information. If there was a power of attorney for personal care, for example, then that parent would have the ability to consult with the doctors.
Thank you. I will have to wrap it up at this point. There are still a lot of questions coming in, so for everybody who's sending them, keep coming in. We're going to reach out afterwards, give you some resources that we've talked about today, take more questions, give you access to Wally. See, that's one of my barking dogs they just discovered about the will. And we want to thank everybody very much for participating. Wally, thank you so much. You're just such a wonderful gift to us. Wally donated his time today, and so everybody please join me in thanking him. Bye-bye, everyone.
A pleasure.
Thank you. Bye-bye.